Oh yeah, it looks like. Please call the case.
Good morning. I'm the registrar clerk for this hearing. Justices of the Constitutional Court, all counsel are online. I call the matter of TM on behalf of MM and member of the Executive Council, Health and Social Development, Gauteng, for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
As it pleases the court, Justice Madlanga and other justices, I appear for the applicant for leave to appeal together with my learned friend, Ms. Weber.
Thank you, Mr. Badlander.
May it please you, Justice Madlanga and other justices, I appear for the respondent together with my learned friend, Ms. Mutige.
Thank you, Mr. Soni. Yes, Mr. Badlander.
Thank you very much, Justice Madlanga. Justice Madlanga, this matter, as this court knows well, concerns the nature and scope of the legal duties borne by public maternity units when managing patients in the context of limited resources. This court will know that the High Court, Judge Fisher, found that the respondent had been negligent. On appeal to the SCA was divided. A narrow majority of 3-2 would have dismissed the claim, and the minority of 2 would have upheld the claim. At the heart of this matter, Justice Madlanga, is the reality that hospitals in South Africa, but particularly maternity units, operate within constrained resources and with finite resources. And that is the reason, as the papers make clear, that even though there are two operating theatres available at the hospital, only one is used over weekends, only one is used at night. Now, that is not the basis upon which we contend for negligence. But what we do say is that where there is a situation where a hospital, a government hospital, decides only to make use of one of its 2 operating theatres, with the inevitable consequence, we say, that there will be patients queuing up in urgent situations and competing claims for the operating unit, it is then essential that there be proper mechanisms in place and proper and efficient utilization of that operating unit so that the tragedy which occurred in this case can be prevented wherever reasonably possible. And we emphasize the 2 points that we have in the heads of argument, the first being the duty to ensure that there is no downtime or no unreasonable downtime in the context of the operating unit, because what that does, exactly as happened in this case, is the downtime didn't affect the patients who were delayed, but the downtime did affect my client and my client's child. And that was the consequence. But secondly, and relatedly, where there is a situation where a patient cannot get access to the operating unit and to perform the emergency C-section within what is common cause of the guidelines, 60 minutes, must be completed within 60 minutes, that's common cause. Where that is the case, efforts must be made to see whether the patient can be referred elsewhere. Now, the respondent apparently takes the view that both of those propositions are bad. It takes the apparent position that it is entitled to choose only to operate one unit of the 2, which we accept, but that in doing so, it is not obliged either to ensure the efficient use of resources to prevent downtime, and I'll come back to that when I come to wrongfulness, and also that it has no obligation to seek to refer patients elsewhere. In other words, the respondent's approach, and I don't mean to be unduly critical, but the respondent's approach, in a sense, is tough luck. If you are the patient who happens to be at the end of the queue, if you are the patient who happens to be in the jam when there are more than one pregnant woman trying to deliver, all of whom need emergency C-sections, the answer is there was no duty on us to use the facilities efficiently at the start, and there is no duty to try and refer elsewhere. And that, we submit, cannot be right. And it cannot be right because this court and the law and indeed the MEC can't fix the problem of limited resources in hospitals. But what the MEC can do, and what the MEC's officials can do, and what this court can insist on, is that appropriate measures are taken to ensure that where there are limited resources, those limited resources are used efficiently, and that it doesn't create the sorts of tragedies that befell the parties in this case. So that, in a nutshell, is the case which we are going to advance. And we propose to do so by dealing with the following issues in turn. First, we will deal with the question of jurisdiction. And in doing so, the question of whether this legal issue has previously been raised before the courts, before the lower court. Secondly, we will deal with the question of wrongfulness. Thirdly, we will deal with negligence. And fourthly, we will deal with causation. Justice Madlanga, I haven't taken 10 minutes, but that is the introductory remark I wish to make. And if I could waive the rest of my protected time and move on to begin addressing.
Thank you, Mr.
Thank you. I thought that was a question immediately. Could I begin with the question of jurisdiction? And we address the question of jurisdiction in our heads of argument at page 4 and following. And in essence, what we say is that the matter falls within this court's jurisdiction on two separate bases. The first is that it raises constitutional issues, and the second is that it raises an arguable point of law of general public importance. Now, with regard to the constitutional issues, we have drawn attention to the decision of this court in to the decision of this court in Mashongwa. In Mashongwa, what this court held is that though it was a delictual claim against the government or against PRASA, Sections 7.2 and 12.1c of the Constitution are the pillars on which the superstructure of the case rests. And the court went on to explain that because it was about the obligations imposed on PRASA as an organ of state by those provisions of the Constitution, and because there was an inquiry into wrongfulness, which was about what the policy and legal convictions of the community constitutionally understood, regarded as acceptable, that rendered it a constitutional matter. We've cited Mashongwa in paragraph 20 of our heads, and it's Mashongwa at paragraph 13. We submit that precisely the same applies here. This is a matter which, though brought in delict, rests on pillars of the Constitution, Section 7.2, Section 12, Section 27, and Section 28. And that last point is particularly important in light of this court's judgment in BE versus the MEC, the recent judgment last year, which I will return to. But there, this court's held that although a matter will not be constitutional merely on the basis that the interests of children are affected, the impact on children is neither remote nor indirect. And the same applies here. Because we say, and I will come to this in a moment, that what is remarkable is that there is a disagreement between ourselves and our learned friends, not just on the facts, but on whether there is a legal duty to manage these constrained resources efficiently. Now, that is preeminently a constitutional question because it goes to wrongfulness. It's preeminently a matter that affects healthcare rights, and it therefore falls within this court's jurisdiction.
Mr. Bartlender, you can go on, my sister.
Thank you, Justice Madlanga. On the assumption that we are with you, Mr. Bartlender, in respect of the downtime and having the second theatre available, just on the assumption, not that we are, the other grounds of negligence, that wouldn't be before us. We wouldn't be able to get there, would we? And also in respect of wrongfulness, if you look at paragraph 6 of the SCA, the majority judgment, it's in the record at page 1582.
Yes.
The SCA found in favor of the applicant.
I apologize, Justice Verona. It's paragraph 6, 1582.
Sorry, it's not paragraph 6. I'll just. No, that's not the paragraph. I'm sorry. But the majority judgment did say they assume in favor of the applicant that there was a legal duty on the respondent. So, now, if we are with you and we have jurisdiction, sorry, it's paragraph 56.
Yes.
Other than in respect of the downtime, and the availability and how the theatre was managed and the availability or the non-use of the second theatre, would we have jurisdiction in respect of the other matters and the remaining heads of negligence and grounds upon which the applicant relies?
So Justice Turon, let me say that with due respect to the SCA minority, I would not in any event press the point about interim measures or triage, because it seems to me that there is insufficient to conclude on that basis. So we do, however, press the point about the referral and the failure to refer to an additional facility. And it seems to me that that is integrally connected to what we say the constitutional issue is, which is the need to manage the resources efficiently, because the management of efficient resources is not just at this hospital, but more broadly. And so we would see that as part and parcel of the same issue.
Isn't the difficulty with the question of referral the lack of evidence, Mr. Butlander? And that arises because it was not something that was canvassed, and that's a consequence of it not being pleaded. So it was not an issue that was what was fully ventilated at the trial.
Yes, I will return to that if I may in a moment, and I accept it wasn't squarely pleaded. We submit it. Our submission is that it was sufficiently canvassed at trial to be taken into account. But if I could just, for the moment, if I could confine myself to the question of jurisdiction, it seems to me with respect that is part of the jurisdictional issue, of the matter which falls within this court's jurisdiction, because it is part and parcel of the debate about what the state has to do when it is constrained, when it is facing constrained resources in a context such as this. But I'm alive to the difficulty of pleading, Justice Turon, on that score, and I'll return to it, if I may, when I get to the question of negligence.
So what is your brief answer then in respect of jurisdiction? Would this court then, on your argument, be confined to the downtime, the second theatre issue, and the referral question?
Yes, those are in any event the only points that we press for purposes of negligence.
Thank you. Thank you, Justice Madlanga.
Thank you, my sister. Justice Turon has touched on what I wanted to raise, Mr. Butlander. Please continue.
Mr. Butlander, I wonder if I could just come in, since it's pertinent to what my sister's been raising. That would leave causation out of account. And the majority in the SCA found that there was no causation. So even if the wrongfulness issue is within our jurisdiction, if causation is out, how do you finally come home in the case?
Thank you, Justice Unterhalter. Sorry, I should have been more clear in my answer, and I appreciate the question. We say that causation is certainly on the table in this court, and let me say so for two reasons. Firstly, because I sometimes think it's easier to think of it in the old way the court used to explain it, that there's a constitutional issue, and then there are issues connected with constitutional issues. If the court concludes that wrongfulness is a constitutional issue that should be determined in the interests of justice, then at worst, causation is an issue connected with that constitutional issue in the language of the pre-amendment to the Constitution. And I've always understood that provided that the court finds that there is a constitutional issue that needs to be determined, the court is then not precluded from dealing with related non-constitutional issues, even if they're factual in nature, and that's always been my understanding. But more importantly, perhaps, and in any event, we say that the causation issue itself merits the attention of this court in light of the judgment in Lee, because the approach that was adopted by the majority of the SCA is, can I call it the traditional test, the traditional causation test, which we understood to, in appropriate cases, have been relaxed somewhat by Lee. And we submit that on that basis alone, the proper test for causation as applied to this context would be within this court's jurisdiction. So in our submission, causation too is within this court's jurisdiction.
Mr. Butlander, excuse me. I just need to clarify one or two things. You say the live issues would be the downtime, the second theater, the referral, and the causation. The paragraph that you were referred to earlier by my sister Tron regarding the wrongfulness indicates that the SCA had assumed that in the favor of the applicant. If you are in agreement with us, that is the correct position. The wrongfulness would be out of the equation for the purpose of deciding this matter. Would I be correct?
Justice Matopo, the SCA assumed the wrongfulness issue in my client's favor, but found against my client on the question of negligence in relation to that. In other words, it found at the level of principle that there could be wrongful conduct, but it found against on the question of negligence, and then it also against on the question of causation. But it seems to me, with respect, that this is one of those cases where it is hard to draw a bright line between wrongfulness and negligence, because in understanding what the precise nature of the legal duty is, one has to have regard to what the duty not to act negligently entails. So I accept, Justice Matopo, let me say unreservedly, I accept that the majority of the SCA found that assumed that there was wrongfulness, but then held that there was no negligence. But my answer is, firstly, that in this case, you can't draw a sharp distinction between wrongfulness and negligence. And secondly, and more importantly, the question of wrongfulness remains a live one between the parties because the MEC contests that there was any wrongfulness. And so when we consider whether it's in the interest of justice and whether there is a live issue of public policy, there plainly is, because the MEC says there is no wrongfulness that's established.
So Mr. Budlander, the assumption that was made by the SCA was made within the confines of determining the question of whether that duty that it assumed existed was breached. That's all.
Right.
And this court is not bound. This court is not bound by that. It's very much on the table, the question of wrongfulness. That being the case, and on the question of jurisdiction, as I read the applicant's case, you're really contending that the scope and nature of the wrongfulness inquiry is sharply raised to the extent that this court is called upon to determine whether the efficient management of resources from the perspective of the public policy and the legal convictions of the public are sufficient to trigger liability, provided there's foreseeability and causation. Does that not in itself indicate a development of the common law in relation to this particular feature of the law of dealing? And it would seem to me it does, if one has regard to the broad test laid down in DZ versus MEC. And if that indeed is the case, we've been cautioned by those judgments that the development of the common law is best done when, as it were, the court has a full view of the lay of the land. And while counsel for the MEC conceded in the SCA that the door was open to the issue of the downtime being raised by the applicant, that wasn't a concession. That case was properly pleaded. And do we not suffer from that deficiency in these proceedings that and it goes to jurisdiction in the sense that whatever you may say, is this a proper case for the development of what may well be an important legal principles that has implications just not for medical services, but I imagine every feature of governmental life, how they manage limited resources.
Justice Collopin, can I begin with the first question you put to me, which is this the development of the common law? And the answer is yes, but a guarded yes. Because what this court has made clear in cases from Phoebus and Carmichael onwards, including to DZ, is that the development of the common law can occur in one of two ways. It can occur where there is no new startling development of the common law, but where it is simply the application of principles of wrongfulness, negligence, and so on to new factual situations. That's the one situation. And then it can occur in a more radical way, such as was at issue in DZ, where the proposal was that a whole new remedy could be developed about how people could be recompensed. Now, the caution that you draw my attention to it seems to me, applies with considerably greater force in the latter category than in the former. We are not arguing for some entirely new head of damage or some new constitutional damage or anything of that sort. All we say is this: in assessing the classic delictual requirements and what the legal duties are in relation, and it was common cause that there were legal duties flowing from the Constitution in relation to the treatment of my client and her baby. When those legal duties are taken into account, one of the aspects is that there must be a duty to make proper use of the facilities available. Now, that is not a radical development. I mean, let me take an example, an absurd example, perhaps. But suppose that the hospital had simply not bothered to open the operating theatre that day. Someone was late for work, there was a strike, something happened, and they simply didn't open the operating theatre. We would all say that there is a duty to make use of the facilities that you have. You have failed to do so. That is wrongful, negligent, and subject to causation. The requirements are satisfied. Now, that's not the fact.
But Mr. Butler, even in that case, it would have to be based on a proper case being pleaded and on a factual matrix. And I understand the two routes you've spoken about, the development of the common law. But as I read, in particular, paragraph 58 of DZ, irrespective of which route one chooses, whether it's the radical development or the incremental development, the court was clear in saying factual evidence to substantiate a carefully pleaded argument for the development of the common law must be properly adduced for assessment. That's the sort of caution that this court has sent out.
But Justice Colopin, my answer is that in this case, the evidence is there. We can debate whether the case is properly pleaded in the particulars of claim. And that, as I understood it, was the concern of Justice Rogers in the court below, and to which my learned friend, Mr. Soni, I wasn't in the court below, but which my learned friend, Mr. Soni, responded by saying, well, perhaps he should have objected to the evidence. But that's the point with respect. The evidence is there because the evidence dealt with the downtimes and the consequences. And because the evidence dealt with the downtime and the consequences, this court can consider what the legal implications are. So this is not a case where there is no evidence, because the evidence is there. And so my submission is that the court is able to grapple with the issue and able to determine it.
Okay, Mr. Butler, I don't want to extend this any longer than, and while the evidence may be there, surely the purpose of a pleading is to enable a party to know what case it must meet. And so if the evidence unfolds outside of a pleading, it may well answer the question, the evidence is there, but it doesn't answer the question, would the respondents privy to knowing exactly what case they were required to meet and to prepare accordingly? But we may get there later. Yeah.
But Justice Colopin, perhaps I could say one last word on that question. I agree, of course, that the cases, and I'm not going to cite them to this court, they date back to Randfontein and a whole series of cases, which this court knows all too well, Milner and all the rest. Those cases make clear that the pleadings are there for the purpose of defining the issues, but that where evidence is led and the trial takes place on a somewhat different basis, the court can grapple with those issues, subject always to the overriding question of prejudice, which you correctly put to me. But in this case, there was no prejudice complained of by my learned friend in the court below. And so the prejudice and the absence of it is fundamental. But perhaps let me deal with it. It is helpful in my submission to have regard to the stated case. Because, of course, the stated case, the court will know that what happened was that there were pleadings, and then what followed was an agreed stated case and issues to be decided. And that appears at volume 9, page 887. And at volume 9, page 887, you will see the following. First, if I could just take you to a couple of references. At page 889, paragraph 2.3, it's recorded that the defendant pleads, the defendant denies that the hospital or its staff failed to perform the cesarean section timeously and pleads that in the circumstances pertaining on the day in question, the cesarean section was performed as soon as it could reasonably be performed. And then if you turn to 892, paragraph 6.4, the defendant admits that by virtue of the provisions of the Constitution, she owed the plaintiff a duty of care to ensure the rendering of legal medical care, treatment, and advice to the plaintiff with such skill, care, and diligence as could be reasonably expected, etc. Oh, and obliging the defendant to ensure that proper, sufficient, and reasonable healthcare services are provided to the members of the public. And then over the page 893, the defendant admits, subject to the availability of resources, the medical practitioners and nursing staff were individually under a duty of care to render the various treatment. And then lastly, and revealingly, at 901, there is the dispute between the parties, the issues for adjudication. And the issues for adjudication, A and B, are not relevant, and C is whether the nurses and doctors were negligent in their care by not performing the cesarean section earlier, given the circumstances in which they found themselves on the day in question, particularly having regard to what facilities and personnel were available. Now, the debate of what facilities and personnel is available must necessarily go to how many operating theatres were available, why, who were they being used by, and to what extent. And when you
Mr. Butlander, is that correct? Because in the stated case that you've just referred to us, there is really an acknowledgement of wrongfulness, or at least that there is a duty, as the majority of the SCA found, to use resources with reasonable efficiency. So the issue in the case was negligence, and you are now wishing to come to this court to develop a whole case about wrongfulness, which you have an assumption in your favor of in the court below. The debate in the court, in the appeal court, was all about negligence, and much of what we are being asked to consider is all about negligence, not wrongfulness, because the duty has been assumed in your favor. Why would we entertain an appeal about a matter which, in a sense, has been assumed in your favor?
Justice Unterhalter, because the extent of the duty to manage one's resources efficiently goes to a debate both about wrongfulness and negligence. And so the two issues overlap. But equally importantly, the minority, ironically, didn't agree that there was any duty resting on the hospital in relation to what had occurred prior to the patient being admitted. You'll recall that the minority, in fact, rejected that contention. So with respect, it seems to me that there is a live issue, both because the minority wouldn't have upheld it, but also because in this court, the parties are directly at odds over whether that legal duty exists. So my answer is, it is in the interest of, it is a triable legal issue, and it's one that's in the interest of justice that it be determined, because it does arise.
So just to understand it, you have a decision in your favor by the majority, which you could rely upon, but we should entertain the wrongfulness issue because it's connected to the negligence. That's the basis of jurisdiction.
It's that, coupled with the fact that, as this court said in Mashongwa, this is a delictual case which is delictual in its superstructure, but it rests on pillars which arise from the Constitution. Because when you have a look at Mashongwa, what Mashongwa says at paragraph 13 is that one of the bases upon which it concludes that it's constitutional is because the claim owes its origin largely to obligations imposed on PRASA by the provisions of the Constitution. And then, in addition, the inquiry into wrongfulness deals with it. So I've always understood this court's jurisprudence to be that one doesn't have to necessarily have a wrongfulness inquiry in this way, and it would be good enough on Mashongwa's approach to deal with this question on the basis that it is really a delictual claim, which, in the words of this court in the Law Society case, Law Society versus Ministry of Transport, it is a delictual claim which gives effect to constitutional provisions. And so...
I'm sorry, please finish your sentence. I don't want to interrupt you.
But so just as this court has often said that the interpretation of a statute, where the statute gives effect to constitutional provisions, without more, that is a constitutional issue. Then similarly, the understanding of the legal position in relation to delictual claims, since the decision in Law Society versus Minister of Transport, is similarly a constitutional issue. And lastly, and sorry, Justice Saran, then I'll come to the question, there is no bright line there between facts and law. The notion that this court is confined to questions of law and not fact, I beg your pardon, is confined to questions of law and may not inquire into fact, went out the window many, many years ago. And so when you take all of that together, I submit that it is a matter that falls within this court's jurisdiction.
If I understand your argument correctly, Mr. Badanda, that would mean that almost every medical negligence case based in delict, this court would have jurisdiction.
It would mean that almost every medical negligence case would fall within this court's jurisdiction, but that wouldn't mean that this court would have to grapple with each case, because of course the ultimate test is the interest of justice. So could I give another example? On that basis, this court has jurisdiction, on the basis of Nahawu versus UCT and the cases that followed, this court has jurisdiction in every labor case. But of course, this court declines to hear every labor appeal that comes to it, because it says some raise important issues for determination, others not. Similarly, every case about the Equality Act, every case about PAJA falls within, every case about PAJA, the review of a dog license falls within this court's jurisdiction, because PAJA gives effect to Section 33 of the Constitution. But of course, this court doesn't hear every PAJA case, because it declines to do so on the basis that some cases raise points of principle and some cases do not. And so you're quite correct, Justice Saran, and I don't want to shy away from it. It seems to me that that's the effect of Mashongwa, but this court controls its, I'm sounding like an American, its docket. This court controls its caseload in a different way by means of the interests of justice, rather than a focus on narrowing its jurisdiction. And that's why it seems to me, it seems to me that it would be inappropriate with respect for this court to find that this case is outside its jurisdiction. The question, in my submission, in light of the cases I've cited, this case is clearly within its jurisdiction. The debate is it in the interests of justice to hear this appeal? And I submit that it is, both because of my client's interests, but because of the broader ramifications.
Doesn't Loriero say, I'm sorry, my sister, my last question. Doesn't Loriero go in the opposite direction? Doesn't it say the opposite to what you're saying in respect of delictual claims, Mr. Padlanda?
I need to reread Lorero. I know it was the security case and it was about, and I know that wrongfulness was at issue. Would you afford me an opportunity to re-look at Lorero while my learned friend is on his feet? Otherwise, I will embarrass myself. But I will need to reconsider it and come back to you on that, Justice Turan.
Thank you. Thank you, Mr. Badlander. Thank you, my sister.
Thank you. Mr. Badlander, in your debate with my brother Kolapen, when you were debating, if I can just remind you, the issue of whether we're asked to develop the common law or not, you said that the evidence is there. Was I correct in understanding that?
Yes, I was speaking about the downtimes issue in particular.
Yes, and I just want to clarify something concerning that downtime issue. I know that from the record, we do have evidence concerning the first downtime period, because there we know that there was that downtime, or it was occasioned by the fact that there was a shortage of gowns. Concerning the second and the third downtime, do we have evidence at all about what caused that? I'm asking this because the respondent in their heads are saying that there may have been a possibility that the doctors, for instance, may have been engaged somewhere doing ward rounds and all of that. But do we know what was happening during that, or what occasioned that second and third downtime?
Thank you very much for the question, Justice Tuki. The question of downtime, I think one should separate two questions. The first is whether there is evidence of the downtime, and the second is whether there is evidence explaining why the downtimes occurred. The evidence of the downtime is certainly there. It emerged from discovered documents, and the evidence of the downtime is there. And in fact, the existence of the downtimes, as I understand it, is common cause. And it's also common cause that if the downtimes hadn't occurred, patients would have moved through sooner and my client would have been seen sooner. Leave aside the causation debate just for a moment. Your point, though, with respect is a fair one, to say that there is no explanation from the other side as to why the second and third downtimes occurred. But that, with respect, is not something that can be laid at my client's door. It was for the respondents to lead that evidence, or for the respondents to object to the evidence of the downtime. So you're quite right that there's an absence of an explanation, but the absence of an explanation is not an issue that can be laid at my client's door. And if the respondents wish to contend they had been prejudiced, then what they ought to have done is they ought to have objected to the evidence at the time, or on appeal to the SCA have objected to that issue being argued, but they didn't. They did neither. And so with respect, it wouldn't be appropriate now for my client to be prejudiced in that way, simply because they haven't given that explanation.
Mr. Butlander, if my sister's finished, may I ask, I share the concern about the wrongfulness aspect because there was an assumption made in your favor. I wonder how Mashongwa and BE, for that matter too, could still be applied in these circumstances. I think you've canvassed that fully. I'm not going to go there again. I just raise this with you to say that I share that concern. And I don't think those cases apply. The paragraphs that you quote were because wrongfulness was assumed in your favor by the majority, because in essence, the appeal is against the majority, which is the decision of the court. But the question I want to ask you is this. In your heads at page 6, paragraph 21, still on this point of jurisdiction, on the arguable point of general public importance, you say this matter raises an arguable point of law of general public importance, in particular, because it concerns the nature and scope of the delictual duty owed by the MEC to mothers in labor. And you say it may be common cause that the MEC through staff owed a duty to the applicant, but the question is whether the MEC bears a legal duty to ensure the efficient use of resources. Now, my problem lies with where you say it is the duty owed to mothers in labor. Surely that right emanates from Section 27 of the Constitution, and it applies to all patients, including maternity patients. Or is the question not, should the question not be more focused, what is the duty owed to this particular plaintiff, to this particular applicant? See what I don't understand is why do you say this is a arguable point of law of general public importance, because it concerns a delictual duty owed to mothers, plural, in labor?
Because, Justice Majid, on the respondent's argument in this court, there is no delictual duty owed to anyone, and I accept that this would have implications beyond mothers in labor, but there is no delictual duty owed to anyone to exercise or to use resources efficiently. That, as I understand it, is their case. They'll correct me if I'm wrong. Now, I accept that different circumstances might require different things. So, an operating theatre that deals with 50 kinds of different things, maybe one allows more leeway. But here we are talking about an operating theatre that was designed specifically to deal with cesarean sections, and the progress of birth and the complications that arise in birth are extremely well known. So the question might be different, where you've got a general operating theatre in one town that has to deal with everything from drunk drivers to COVID patients to whatever. But here we're dealing with an operating theatre specifically designed for that purpose, and where one operating theatre, the second one is not operating, not functioning due to a decision. The question is, in those contexts, is there a duty to use those resources efficiently? Now, if you say to me, isn't the duty about this person, my client, I accept that is so, but that would have ramifications for other clients and other people, because the duty is a legal duty.
I'm not sure that answers the question, but can you just explain to me, why do you say the respondent's case, as you understand it, is that there's no duty owed to mothers in labor generally? Does that emanate from the pleadings, from their plea? Does it emanate from the evidence? Where does that emanate from?
Well, when I have regard to their heads of argument, and that's what I have focused on, when I have regard to their heads of argument at paragraphs 43 through to 55, they devote a spirited argument to contending that there is no wrongfulness, and they try to call in aid this court's judgment in BE. So they say, well, look what happened in BE. In BE, there was a finding that there was no wrongfulness. And similarly here, this is at most a public duty. That's the way they frame it. It is at most a public duty, and therefore it cannot give rise to any delictual liability. You see it particularly at paragraph 53, Based on the foregoing, it's admitted that the alleged failure of the MEC in this matter to ensure that resources are used efficiently does not constitute the breach of a legal duty as opposed to a public duty, and thus does not, and accordingly does not found a claim for delictual damages. So there is a square dispute as to whether there is a duty to use these facilities efficiently. They say no, we say yes. And we say, and perhaps I should deal with it immediately because I'm mindful of time, we say that their reliance on BE for that proposition is entirely inapposite. BE was a debate about whether a statutory provision and particular regulations created a legal duty sufficient to claim damages. In other words, it raised the questions that have frequently been raised in our law, in Olitsky and Steenkamp and the run of cases that dealt with that. That's not what we're dealing with here. We are dealing here with where there is an admitted legal duty to take reasonable measures to safeguard the healthcare of the patient concerned, where it's admitted that that flows from the Constitution, which it must, but the debate is, does the Constitution include a duty to use those resources efficiently? Does the legal duty include that? Now, that is a world apart, in my respectful submission, from a debate about whether a particular statute creates a delictual duty in that way. So that's the answer to your question, Justice Majid. That is why I say there is a sharp debate between us on whether such a legal duty exists and what it entails.
Yeah, all I want to say in conclusion is that it seems to me that particular answer you just gave brings us back to the original conundrum, which has already been enunciated by some of my colleagues, is that how does wrongfulness feature in this debate, both in jurisdiction and the merits, where there has been this assumption? But I mean, we're back to square one. So I'm going to leave it there for now. Thank you.
Yes, I'm not sure I can take my answer any further than I have. Safe to say that it really does seem, when I read the SCA judgment, that although it might have assumed that the legal duty existed, its apparent skepticism of that legal duty appeared to shade onto its findings of negligence. And I do think that this is one of those cases where the two things are not neatly separable. But I will give it some more thought, and if I have a better answer, I will offer it to you. But that I'm not sure I can take it better at this stage.
No, I said I'm finished, but let me just ask you this: if we exclude wrongfulness, if we come to the conclusion, just hypothetically speaking, that wrongfulness should not feature in this debate about jurisdiction because it's no longer an issue, it was an assumption in your favor. We're left with negligence and causation. As I understand it, you peg jurisdiction here squarely on Lee and only Lee, am I right?
On the question of causation, that's right, yes.
Correct. And then as far as negligence is concerned?
Now, I accept, if this court, I must make the concession that if this court finds that wrongfulness cannot be an issue here, and that wrongfulness and negligence are entirely separable from each other in the context of this case, then I accept that this court would not, there would be no crisp legal issue to determine, because the negligence turns primarily on the facts. And I accept, as I must, that the majority found against my client both on negligence and causation. So the finding of causation doesn't assist me if I can't get this court to look at the negligence. So I make that concession.
Right. Thank you.
But for the reasons I've articulated, it's my submission that would be the wrong conclusion to draw.
Yes, no, I take your point. Thank you.
Mr. Butler, just a small point for my own clarification. I've been listening to the debate, especially about the legal duty, but I'm just focusing on the downtime argument that you raised. That is, if we get there, does it matter at all that when fetal distress was detected, it was hours after the last downtime?
Thank you, Justice Mlambo. Let me address that point because it goes to the merits, and I do want to make sure that I've covered that. Justice Mlambo, you would have noticed that the SCA minority judgment, in fact, found against my client on that score because they found that the duty of care only arose when my client presented at the hospital. And that links to your point about the fact that
Yes.
the fetal distress was only detected thereafter. That, with respect, seems to me to be the wrong answer. And the question you posed to me is not correct in my submission. And let me explain why. We are not dealing here with some unforeseeable event. I go back to my point that we are dealing here. The question that appeared to be posed at times in the SCA and that appeared to be posed by a learned friend is, could they foresee at 9 o'clock in the morning that my client, Ms. M, would arrive and that my client, Ms. M, would develop fetal distress and that she would need an urgent cesarean? That, with respect, is the wrong question. The question in my submission is whether they could foresee at 9 o'clock in the morning or 5 in the morning or whenever the first, or more importantly, the second and third downtimes occurred, that there was a real likelihood that other pregnant women were going to arrive and that some of them may develop fetal distress, and that if they develop fetal distress, there would need to be an emergency Caesar. And that was the question. And in my submission, it's obvious, just as a matter of logic, that that was foreseeable. They didn't have to foresee the specific identity of who it was, and they didn't have to foresee the precise time it would occur. And you can think of it this way. Suppose that at 9 in the morning they had said, you know, there are actually no patients today, and we have decided simply to shut the ward, and we'll all go and take a day off. Well, and then my client arrived. We would all have little hesitation in saying that their decision to close the ward or close the operating theatre or send home the anaesthetist had a direct impact on my client's rights, and that amounted to a breach of legal duties and negligence. So the same applies here. If it is shown, and I accept it has to be shown, but if it is shown that there was a duty to manage the operating ward efficiently and that duty was negligently breached, it doesn't matter that duty was breached before my client started suffering fetal distress. That, to me, with respect, in my submission, is not an answer to the proposition.
Can I, Mr. Bartlender? Can I, Mr. Bartlender, give you a different hypothetical case, probably similar to this one? A group of specialists, that is your obstetricians and gynecologists, sit. They decide, we've got this one ward today, it's a Saturday, and they sort of book time slots during which they think, or they are going to use the theatre. They use that in order to share the theatre amongst themselves, and it is based on the patients that they have at that particular time, right? And after they've done that, there is a time period during which the theatre is not being used. That is now similar to the second and the third downtime, right? And they go about their business in the wards and attend to the other patients and to the other scenarios. During that time when the theatre is not being used, 2 cases, emergency cases, arise, and those are accommodated, right? And this is why I said it's similar to the present scenario, my hypothetical case. So the theatre is used. Then comes the time for the bookings for the patients that were there. And then one patient is taken and used, and the theatre is used. But it so happens, unfortunately, that during the time when the theatre is used, a patient whom they had examined before and had decided that there is no need for urgent intervention on, suddenly has complications. I'm battling with finding how to impute negligence in that scenario. Because this is a patient who arrived earlier, was examined in terms of the guidelines, and there was no need for that patient to use the theatre. And we know from the facts that during that time of the downtime, emergency cases were attended to. Now, I've got a problem with imputing negligence in those circumstances. And also factor in your foreseeability issue, because I don't quite understand how it can be factored in those circumstances.
Justice, it seems to me that the correct starting point with respect is when that group of specialists makes an allocation for the day, do they do so anticipating that no new patients will come in who require who require emergency treatment? Let me take a step back. There are two ways one can do it. One can allocate the surgeries or the procedures on the assumption or the premise that there will be no further need for surgeries that day, or a very limited need for surgeries that day. The alternative is
let's say they allocate the time slots with that in mind, with the fact in mind that there may be emergencies, and if an emergency arises, we will immediately go to theatre.
But then, with respect, then if they were going to allocate on that basis, then absent some compelling reason, they would try and do all of the surgeries as early and as efficiently as possible. If you are allocating on the basis that you assume that more emergencies are going to come in, then you do the non-emergencies or the ones you can control as early as you can to make sure that if an emergency arrives at 12 o'clock or 1 o'clock or 3 o'clock or 4 o'clock, you will have an operating theatre available. You don't spread them out throughout the day, which increases the chance of a queue and a concertina and the very problem that emerged in this case. So that's, you see, that's my submission, is that there are two ways of doing it. You either allocate on the assumption that there will be emergencies or may be emergencies, or you allocate on the assumption that, well, there are no emergencies, so we assume that there will not. If you adopted that latter part, it would be negligent in my submission, because you, in a hospital of this kind and in a ward of this kind, you must assume that there will be more coming in. It's an inevitability.
Mr. Butler, wouldn't it be helpful just to look at the facts in this case? I mean, the critical question is, Ms. G could have been accommodated earlier during the third downtime, but the facts are that at 9:50, she was considered that it might be necessary to give her a C-section, but the only determination that she should proceed to a C-section was at 4:15 in the afternoon. And then the decision was taken to take her before your client. So on the facts of this case, even if you apply your efficiency consideration, it's not clear that there was, that the decision not to accommodate Ms. G earlier was a negligent decision, because there wasn't an apparent clinical pressing need to accommodate her earlier, even though technically looking back, she could have been accommodated during the third downtime. And that's why on the facts, the question as to what Dr. Sibeko was doing by way of her other duties is such a critical part of this. And as to that, no one could reconstruct it. And Dr. Chauke spoke about the many other things that she may well have had to attend to during the day. So isn't that the practical problem with showing negligence on the facts of this case?
Yes, Justice Sonthofer, I accept that is the analysis that has to be performed, but I was trying to answer the hypothetical first about what the duties are. But if we turn to the facts, and we turn to the facts, for example, regarding Ms. Munchenzi, she was eventually taken to theatre for delivery of her twins 9 hours after the time originally scheduled for her operation. Yeah, but
just in the analysis of how could it have been done so as to avoid the clash that occurred at 4 o'clock in the afternoon, where they had to choose Ms. G over your client, which is what led to the delay. The real issue is, when otherwise could Ms. G have been accommodated? And those are the critical facts that are relevant, I think, ultimately to the negligence question here. One can play many, many scenarios, but as is played out practically, there had to be a choice made between Ms. G and your client, and your case must surely be that choice could have been avoided, but the question is, could it?
Yes, but Justice Unterhalter, if I could say, it's one thing if one is going to say at the level of causation, even if Ms. Muchenzi had been accommodated within the 9 hours after her operation was directed, and even if Ms. Maluleka had been taken earlier than 3:30, when in fact the decision to perform the C-section had been taken at 1:45. Just if I could assume that for a moment, it's one thing to say, if those things had been done, it would have made no difference because you would have had two patients at the same time, and it was then just a debate about Ms. G versus my client. I understand that proposition. But with respect, I didn't understand that that was the effect of the evidence. And I didn't understand that that was the way it was argued. Because my understanding was, in fact, there was a concertina. And so even Ms. G was later than she ought to have been as a consequence. I will re-look at it, but my understanding of the evidence was that. But I accept your proposition that, of course, there will sometimes be situations where three people arrive simultaneously, or one has been there for hours and then develops complications as another one.
I think the facts are these, that there was an understanding at 9:50 that Ms. G may have required a C-section, but there was no immediate urgency to give it. And then the decision was taken later in the afternoon that indeed she needed it. And that's when the triage decision was taken to prefer her, because there was a threat to her life. And there seems to be a principle that if the mother and the child are at danger, you take that case first.
But my understanding of the facts of Ms. G was slightly different. It's that she was admitted, and that because she had previously undergone 2 C-sections, it was clear that at some point she would require the C-section. The only question was, when did it become, can I use the word essential, as opposed to an option? Now, if that is so, with respect, and if one is dealing, in other words, if one knows that Ms. G is going to need a C-section, and the only question is, should we perform it at 10 o'clock when it is medically possible? I'm just taking that as, should one perform it at 10 o'clock when it is medically possible but not yet essential? Or should one wait until it becomes medically essential? My submission is that that is negligent.
No, but you see, Mr. Budlander, the difficulty here is the other component of that consideration, which is what else did Dr. Sibeko have to do on at least 3 wards that she appears to have been responsible for? And as to that, there's a great paucity of evidence. But if you're going to use a reasonable efficiency standard, that is essential to understand. And we don't have the facts. And it's not clear that your client didn't bear an onus in respect of those matters.
I accept immediately, Justice Unterhalter, that there does need, that is a relevant consideration. Doctors don't only have to do operation one after the other. There are other duties. I accept that. But I also accept that there's a paucity of evidence on that score. But with respect, I disagree if there's a suggestion that my client didn't discharge the onus, because really the only explanation that could have been given about what else she could have been doing could have come from the hospital.
No, but that's precisely the problem about a case that's not pleaded and is simply raised in the course of evidence. I mean, a proper case, properly pleaded, the documents as to what happened on that day would have been procured, because no doctors are going to understand 8 years later what happened without the medical records. And Dr. Sibeko had regrettably died. So, of course, these things had to be done. I'm not certain that your client can simply say, well, we introduced this in evidence at some point and then the onus shifts.
I understand the proposition, Justice Unterhalter. I can't take it further than I have, which is to say that the evidence wasn't objected to and that my learned friend accepted in the court below that it was a legitimate issue for trial.
Mr. Budlander, just moving to another aspect, the referral issue. Who had the onus to adduce evidence on the referral point? And was there sufficient evidence for one to find against the respondent in that regard?
Yes. Justice Mhlantla, I accept that the onus to adduce the initial evidence on the referral issue rested on my client. And I accept that the evidence on that score is thin. Can I put it no higher than that? I would face difficulty in contending that the referral issue alone was sufficiently dealt with at trial in order to give rise to a finding of liability. That's why it seemed to me that the appropriate approach was to understand the referral issue combined with the efficiency issue or the downtime issue. But what is remarkable, Justice Mhlantla, is that the respondent takes the view that there was no duty to refer at all. Their view appears to be that the only duty to refer is where a patient can't be accommodated in the hospital at all. That's what they say the policy means. Now, again, that simply must be wrong as a matter of principle. How can it be that you admit a patient, it turns out that the patient needs emergency medical treatment because of something that developed once they've been admitted? You can't give it due to resource constraints, and then there's no duty on you to refer elsewhere at all. And that is the difficulty that one has. This is not a case where the respondent has put up a defense which says, these are the considerations we took into account, we tried to refer, or this is why we didn't refer. One doesn't have that. They've adopted an absolute stance of saying there's no duty to refer at all.
Well, they did say that the hospital is an academic hospital, and that's why they don't have protocols. Surely the plaintiff would then have to adduce evidence to say, well, this is what you could have done. You had the ambulances, there was a nearby hospital. The plaintiff didn't do that either.
Well, the plaintiff led the evidence of Dr. Murray, as I have it, which was that at Tygerberg, that's precisely what happens, which is that at Tygerberg, which as I understand it is also an academic hospital, that's precisely what happened, where when one can't accommodate, then an attempt is made to refer elsewhere. So if you're asking me, was the evidence led as emphatically as it ought to be, the answer is no. But if you're asking me whether there was any evidence to deal with the referral issue, then my respectful submission is that the answer was yes, Justice Mhlantla. Justice Madlanga, I'm sorry, I don't know if that was another question or.
No.
Thank you. Justice Madlanga, I have covered a lot of the ground, although not necessarily in the order to which I had intended. I see Justice Unterholzer smiling.
Justice.
I know exactly. That used to happen to me as counsel.
It happens to the best of us.
I'm sorry, Mr. Justice Matopa.
Mr. Badlander, there's an issue that worries me.
Yes.
And it's an issue that allows you to be at the door of this court. And if that issue is not surmounted, and I want you to clarify it for me, whether I understood you correctly, or whether there is still an opportunity for you to satisfy the jurisdiction of this court. You made the concession, and when the issue of wrongfulness was debated, and you said if this court finds that that finding was made in your favor by the SCA, and this court is inclined to follow that approach, the only issue that are available or open is the issue of negligence, which you were canvassing, and as well as the issue of causation. And you did say that there will be no legal issue to be determined. If I understood you correctly, on these two remaining issues, that is the negligence as well as the causation, can this court find any jurisdiction on the two issues that you've raised? I say this in the light of what this court said in Boysen, Jiba, and other related cases. Whether do you come through or you don't? And if you don't, then it would mean that because you seem to have packed your case on the issue of wrongfulness, I don't want to misconstrue you, and I want you to clarify it for me whether if you don't come through, that's the end of the matter or not.
Thank you very much, Justice Matopo.
Just a minute, Mr. Badlander. Colleagues, the 1 hour is up, and Mr. Badlander said he is done. He will go on for as long as you continue asking questions. Thank you, Mr. Badlander. Please continue.
Thank you very much, Justice Madlanga. Justice Matopo, you have correctly recorded my concession, save for one important caveat. And so I'm grateful that you put it to me. The caveat was that I assumed, for purposes of that answer, that one could draw a sharp line or a sharp divide between negligence and wrongfulness. In other words, my answer that I've given consistently is that in this case, one can't draw a sharp divide between negligence and wrongfulness. And therefore, my submission is that the assumption by the majority of the SCA that wrongfulness was established is not sufficient to deprive this court of jurisdiction. But if this court finds that one can draw a sharp line between negligence and wrongfulness, and if this court finds that the wrongfulness issue is not on the table because of the assumption of the SCA, despite the denial of the respondents. So it's in those two instances. If this court says that you can draw a sharp line in this context between wrongfulness and negligence, and if this court finds that the wrongfulness is not on the table for the reasons that we've debated, then I accept that there would not be jurisdiction. Or no, let me put it differently. Then I accept that it would likely not be in the interest of justice because there would be no crisp legal issue that arises. I persist in saying that it is within the court's jurisdiction, like the labor cases and the Padja cases, but I accept that then the court is not grappling with a particular legal issue. And I'm open to the criticism that it's just an appeal on the facts. So I hope I've answered that sufficiently clearly, Justice Matopo.
Well, you have, because it worries me. I did not want to record the concession when it's not properly made or properly recorded. So if there is no sharp line to be drawn and the issue is not open, you don't come through.
I accept that. And I accept that not because this court would lack jurisdiction, but because it would not be in the interest of justice.
In the interest of justice to deal with it. Okay, thank you. Thanks.
Of course, it goes without saying that it is very much in my client's interests, and to her it means the world. And one mustn't lose sight of that. But I accept that the interests of justice are not confined to the individual tragic litigants before this court, but also include the broader public. And that's the reason that I make the concession that I do.
Mr. Badlander, if we were to go into the question of a duty of reasonable efficiency, I would like to hear you, albeit briefly, on what the content of that duty is, because I have two subsidiary concerns. The first is that efficiency is by and large an economic concept. It's about inputs in versus outputs. And a lot of time is spent by management consultants and others trying to understand what efficiency is. But I'm not certain that that usually forms part of the domain of the law of delict. And the second is that to impose such a duty on state institutions, whilst it might be a very desirable end, might be to impose duties that are simply incapable of performance.
Yes. Thank you, Justice Ntalta. When we speak of efficiency, I think we mean something quite simple. Might be too simple, but I think it's simple. It is the idea that where one is dealing with scarce medical resources, and that's what we're dealing with here, that's why I started with the single operating theatre that's available. When one is dealing with scarce medical resources, and where one is dealing with life and death consequences of an inevitable crowding of those resources, then one must try and use those resources reasonably efficiently. That's the way I would put it. We don't
What does that mean? What does that mean?
I'm coming to that. All I'm saying is we don't suggest there's perfect efficiency or anything else. But what that means in my submission on the facts of this case is that one should not allow scarce medical resources to lie fallow, to be unused in the absence of a compelling reason for that. In other words, if you are dealing with scarce medical resources and you are not going to be using them for a period of hours, in circumstances where it's foreseeable, as I've explained, that that's going to have life and death consequences, then of course, sometimes that will be necessary, but you must have, I've used the word compelling reasons or proper reasons for your decision to do that. It cannot be simply a debate about, well, it's more convenient or it's better for the nurses or something like that. You must have proper reasons in that context. And that goes with respect, Justice Winterhalter, to your second question. I'm not suggesting that there is necessarily a duty of efficiency on every organ of state that does everything. But I am suggesting that there is some duty of efficiency on organs of state dealing with scarce medical resources where the consequences are life and death. And so it's a narrower proposition than might be thought if we speak about a duty of efficiency across the entire state institutions.
Does the fact that the applicant did not specifically plead that those medical resources were not used have a bearing, if any, on the outcome of the case? Or can we say that there was evidence adduced which would have indicated to the respondent what case it had to meet, albeit midway through the trial?
Justice Matopo, I think the answer is twofold. If the question is this a triable issue on these pleadings and in light of the stated case and the evidence given, my answer is yes. It is unquestionably a triable issue. And I would refer the court, let me just give the court the references very briefly, 3 references. It's the case of Robinson versus Randfontein Estates, 1925 AD 173 at 198. It is the case of Schill versus Milner, 1937 AD 101 at 105. And it is the case of Imvula Quality Protection versus Lorero. This is in the SCA, 2013, volume 3, SA 407 SCA at 423 D to E. All of those cases are authority for the proposition that where the evidence has gone in a somewhat different direction from the pleadings, but no one objects and no one cries prejudice, then those are triable issues. So if you ask me, is it a triable issue on these pleadings and in light of the evidence, the answer is yes. If you ask me the question Justice Colopin put to me, which is, should we be developing the common law where this issue has not squarely been pleaded in that way, I accept that might be a different question. And I accept that that is a factor that the court will take into account in the interests of justice.
With your leave, Justice Madlanga, Mr. Badlander, if I can follow up on the questions that Justice Nhlanhla had asked you about the referral issue. Doesn't the applicant face another challenge? Not just the challenge relating to the sufficiency of the evidence and whether or who had the duty to produce further evidence. Is it that the SCA made a factual finding in that regard? And that's to be found at paragraph 106 of the judgment. In respect of the protocol and the absence of the protocol, the SCA said the absence of the protocol doesn't mean that the medical staff would have closed their minds to the possibility of a referral. It says, the question was simply not raised with Dr. Shauke. We do not know what other public hospitals existed, whether an ambulance service was available, what distance each such hospital was from CMH, what their facilities were, how long a transfer would have taken, and whether the facilities were likely to have been available to the applicant sooner than at the hospital where she was. How does the applicant get past that hurdle?
Well, Justice Turan, I say again, it's not as though factual findings are beyond reconsideration by this court once this court has jurisdiction. So if the question is the court bound by that, then the answer is no. If you're asking whether the finding is correct, I can really do no better than say what we've said in our heads of argument, which is to say we submit that it's not correct. But I'd be hard pressed to argue it much more than I have already.
Thank you, Mr. Badlander. Thank you, Justice Madlanga.
Thank you, Mr. Mr. Badlander, thank you very much. Let me just look at the time. It's close to 1:15, at which point we would have adjourned anyway. Let us adjourn until 11:30. Court adjourn.
Will adjourn until 11:30. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone and then rejoin with video and sound when the hearing recommences at 11:15. Should you exit, you may use the same link to rejoin the hearing.
Justice Madlanga, I do believe we're just waiting for Justice Chikli, who is now joined, and Justice Mlambo. All the judges are online as well as counsel. You're on mute, Justice Madlanga.
Yes, Mr. Soni. Thank you very much, Mr. Chair.
Thank you so much, Justice Madlanga and the other justices. Justice Madlanga, earlier in the day, you asked whether the 10-minute rule is something I was going to exploit, and I did indicate I would. I had prepared an opening address which I wanted to raise in light of the interactions between the justices and my learned friends. I'm going to change that somewhat and raise the following issues. One of the issues that arose during the exchanges is the question of wrongfulness. And I want to make the following points in regard to our view as to wrongfulness. The issue of wrongfulness is addressed in two parts of our heads. Firstly, at paragraph 24, and then at paragraphs 43 to 54. I do think it is important for me to make the position of the respondent clear in regard to the question of wrongfulness. When we raise the issue at paragraph 24 of our heads, we raise it in the following context, that the issue of wrongfulness does not arise in this matter because it was a delictual claim where, as has been pointed out, it was agreed that there was a legal duty on the MEC to ensure that there was proper treatment for the plaintiff. And so the purpose of raising the issue of lawfulness at paragraph 24 was to say that does not come within the jurisdiction of the court. And there we deal with the difference between this case and the BE case, where this court then said, where there is a question of a legal duty, then is there, how does one determine whether for the purposes of the law of dealing, wrongfulness arises, and in fact, one is entitled to claim damages on the basis of dealing, because the issue is a public law remedy. One of the issues we raise there is, in making that determination, one looks at the various statutory requirements. And when we dealt with the issue at paragraphs 43 onwards, we dealt with the question of the approach suggested in BE and why, if this court was of the view that the issue of wrongfulness is a live issue in this matter, and that is disputed as is set out in paragraph 24 of our heads, then the manner in which the issue of wrongfulness ought to be determined. I thought I should place that so that the court understands and all the justices understand that we are saying that because this was a delictual claim and the issues that arose both in the High Court and the SCA, and we make the point, the only issues that arose in the High Court and the SCA were the questions of negligence and causation. The question of the legal duty never arose, and therefore, within the context of the law of delict, wrongfulness was never an issue. We do not say it is an issue now, because we accept that this is a delictual claim, and that the requirement of wrongfulness and harm have been met because of the duty of care. The second issue that I want to raise is the manner in which the respondent directed that this case be led. This is a somewhat unusual medical negligence case than what one ordinarily experiences. The ordinary ones are where it is said, well, the staff were negligent because they didn't monitor properly, or they didn't do the following, which is in terms of the protocols. Here, the question is, was the conduct of the medical staff on the day in question negligent because the theater was not being used at certain times? Now, 2 points need to be emphasized on that issue. Firstly, the issue had not been raised in the pleadings, but because it concerned the child, the instructions were, do not take technical points on this matter. Deal with the matter on its merits. And that is the reason why Dr. Chauke was called. Dr. Chauke was called effectively to deal with the question of why is it that on weekends, only one theater was being used and a limited number of staff members was being used. So that as is required in terms of the judgment of this court in Mashangwa versus Prasa, which at paragraphs 41 to 43 pointed out that when it comes to delictual claims, what one must take into account is when an organ of state, and obviously therefore a state department, is the defendant or respondent in a matter, the usual rules do not apply. What is required is for the organ of state to present all the evidence that is available. And that's exactly what we did with all the records that became or that appeared to be relevant having regard to the pleadings. All of those were made available to the trial court and are now part of the record. So in that sense, when there is reliance placed on Mashangwa, we make the following point, that in Mashangwa, there were two issues. One concerned whether the issue of security guards, the question of negligence in relation to security guards had been established. And I think it is at paragraph 43, the court said, well, there isn't sufficient evidence, and therefore the negligence has not been established, and that part of the claim failed. Of course, the claim based on negligence in regard to the open doors succeeded. But I only make the point because it is suggested that in some way the burden shifts because it's an organ of state. That's not what we submit Mashangwa means. Mashangwa means that as an organ of state, you are under a duty to present all the evidence because of the constitutional requirements of accountability and responsiveness. And once that is discharged, then the ordinary rules relating to delictual claims, insofar as the onus of proof goes, would continue to apply. The third point I want to make is that the difficulty in this case arises from the following in regard to the downtime issues. And it arises in this context. The birth took place in August 2010. The proceedings were, the action was instituted in 2014, nearly 4 years later.
Mr. Soni, I'm sorry to interrupt you mid-sentence. The 10 minutes is up. Please continue.
As you please.
Please
if there are any questions, I'll accept them.
Yes, but continue with you.
But I just wanted to make the point that what I'm happy to take questions. I had intended saying something and it just
just continue with your submissions. Yes, I'm sorry for having interrupted.
No. I understand.
But continue with the rest of your submissions.
Mr. Soni, you were telling us that the birth happened in 2010 and the institution of the proceedings was in 2014. You want to continue from there? Because I'm interested to hear what you want to say.
Yes, and the trial took place only in 2018. So you have an 8-year gap. As Justice Unterhalter pointed out to my learned friend, that the limited information that is available must be seen in relation to that gap between the time of the incident and the time of the trial, when the position could be placed before the respondent's position could be placed before the court. Now, the issues we submit that are before this court are 2 issues only, namely, was the alleged negligence proven? And secondly, was there a causal link between the negligent and the unfortunate consequence? We submit neither of these is a matter that ought to engage the attention of this court. And in that context, we submit that leave to appeal ought to be refused. We submit that to the extent that having regard to the proceedings and having regard to the basis on which the applicant had made her claim, namely the ordinary rules of delict, I came to a state health facility, I expected to be dealt with the necessary care, and that's not what happened. In that case, the issues that ordinarily arise are the question of wrongfulness, the harm, the negligence and causation. And we submit that those are the only issues that arise. Of course, what has happened now, and we've made the point in our heads, for the first time, the issue is broadened. It wasn't even broadened in the SCA, but it is broadened, and we don't say to invest this court with jurisdiction. But the question really is, on the test applied by this court in Jiba, is this court's jurisdiction engaged? In other words, does it raise a constitutional issue, or does it raise an arguable point of law that this court ought to adjudicate upon. Now, we submit when one looks at the pleadings and one looks at the ordinary rules, and that's what JIBA says we must do, then all that is left with, there are 4 issues. And when the applicant now comes and raises the question of wrongfulness, which was never an issue in the High Court, it was never an issue in the SCA. And the question of wrongfulness arose in the SCA on the following basis. Based on the AN case in the SCA, the respondent had contended that the court, our code, ought not to consider in regard to negligence the downtimes that had taken place before the plaintiff had been admitted to the hospital. Now, the minority in the SCA accepted that point, but the majority said it would not decide the point, and it would make a finding on the assumption that the AN case didn't correctly reflect the legal position as far as the MEC's duty of care to the patient goes. Now, that is what is before this court, a finding that on the basis that there is wrongfulness, is the matter, is the conduct negligent, and is such negligence causally related to the unfortunate consequence? And we submit.
Excuse me, Mr. Sodi. Insofar as the question of wrongfulness, is your argument that let me put it differently. What else could the applicant have done to bring that issue before us? Could they have launched a cross appeal against that decision of the SCA on the assumption of wrongfulness or not?
Well, Justice Matapo, my answer is you can't appeal against a matter that has been decided in your favor. For example, we could not have appealed against the SCA's decision because it was in our favor. Now, the respondent has appealed against the decision, but what it tries to do, though, is the decision is based on factual matters, namely negligence and causation.
No, perhaps I did not make myself very clear.
Yes.
I said insofar as the plaintiff stroke applicant is concerned, and if it was not happy or it was not happy with the issue relating to a finding made by the SCA on the wrongfulness, for example, was it open to the plaintiff stroke applicant, let me just say, stroke applicant to cross appeal or do anything for it to be able to bring itself within the confines of this court's jurisdiction? In absence of that, what else is left for them?
Justice Matapo, if the plaintiff attempted to widen the ambit of the dispute before this court to the question of wrongfulness, it would affect 167 of the Constitution, because that tells us the bases on which this court will exercise jurisdiction in respect of matters before it, which is why that is the first door through which a plaintiff must walk, that it involves either a constitutional issue or an arguable point of law. Now, those issues do not arise, and we submit that the plaintiff there is no avenue for the plaintiff to ask this court to exercise jurisdiction.
Mr. Soni, if my brother Justice Matopa, yes, he has, I see him putting himself on mute, excuse me. The ACA made an assumption in respect of the legal duty and in respect of wrongfulness. It didn't decide the matter. That's the majority judgment. The minority judgment disagreed with them on this aspect. Could it not be said that it's necessary for this court to make a decision on that question? And would that not engage our jurisdiction?
Justice Theron, my answer to that is that would be doing exactly what Justice Matopa was suggesting, namely to enter the court through a mechanism that the procedures do not allow. An appeal must be launched on the basis of the findings of the court. Now, the finding of the court is that there was no negligence and causation had not been established. I want to make the other point, Justice Theron, and I know you did debate it with my learned friend, that there are several issues that have arisen as perhaps negligent conduct. One was the so-called downtime issue, and the other was the referral issue. Now, we submit that in regard to the referral issue, the question of this court's, the question of unlawfulness does not arise. That's simply a question of you should have done this, you didn't do it, and therefore you are negligent. And so one comes back to the old question, the question, is this court's jurisdiction engaged in respect of the referral issue? And we submit it as not. But in regard to the downtime issue, this is what has arisen based on the application for leave to appeal. The applicant says that the question of whether or not there was an efficient use of state resources on the day in question is a matter that raises a constitutional issue because of Section 195 and the issue of responsiveness and accountability and so on. Now, that is not a matter that is live. It was not before the court, our code. It is not before this court because the only manner in which it can be before this court is if the issue of wrongfulness is a live issue. I've already indicated that the position of the respondent is that wrongfulness is there. What has not been established is the question of negligence. And so in short, Justice Theron, my answer is it would not be open to this court to open the door on the issue of wrongfulness on the basis that the majority, that it is necessary to decide that issue.
But that was going to be my sorry, Justice Colvin, my last question. Mr. Budlender's opening remarks was that it is necessary for this court to decide the nature and extent of the duty resting on the respondent. Now, what the SCA, the majority judgment, did was to say we assume and we accept that there was this duty, and then proceeded to decide the matter. The minority made a decision on this matter, but in a different direction.
Yes.
And because the SCA did not decide the matter, and I think I'm almost restating my first question in a way, but in a different manner, wouldn't there that then be a duty on this court to decide the nature and extent of the duty on the respondent? And would that not be a point of law within our jurisdiction? Arguable point of law.
Sorry, I wanted, could I throw in my question to piggyback on Justice Theron's question, because then it might just make it easier, if I may. Mr. Soni, I'm just wondering if the facts were slightly different. So it's common cause that the SCA made an assumption but did not make a decision on wrongfulness. Let's assume that the SCA found in favor of the plaintiff on the question of negligence and on the question of causation, right? And the MEC then approached this court and said, well, you must entertain the matter and your jurisdiction is engaged on the basis, indeed, that the question of wrongfulness is alive, because we disagree with the findings on negligence and causation, but those are factual issues. However, on the question of wrongfulness, that assumption that the SCA made was not a decision. Would this court's jurisdiction have been engaged then? And if it would have been engaged then, why would it not be engaged now?
Can I just respond to that in the following manner, Justice Colbert? If the SCA had decided that that negligence had been established, we would have been entitled, if the SCA had decided negligence had been established and causation, and we had lost, it would be on the basis that the issue of wrongfulness had been decided against the plaintiff. But in this case, but that's the, and it would then fall into the test laid down in Lorerio's case, which is that a finding of wrongfulness would be, or an appeal against a finding of wrongfulness would be a matter that would engage this court. So that test has already been set by this court. It is not just any finding in respect of wrongfulness, it is a finding against wrongfulness being present. That was the test in Lorerio, and that is how this court exercised jurisdiction in Lorerio's case. And so my answer would be that the jurisdiction would arise because wrongfulness would be a live issue. Wrongfulness is not a live issue in this case. May I then go on to the second issue relating to the reliance on the DE case? Now, it will be recalled.
I'm sorry, Mr. Soni. Could you,
yes,
please, could you answer my question?
The answer then, Justice Theron, is that if one were to say that it is a matter that ought to be considered by this court because it's an arguable point of law, not because it's a live issue. Then the question really is, then the court ordinarily would have jurisdiction because it's an arguable point of law. The question though really is it an arguable point of law? Because if one looks at the question as it arose in the BE case, the question there was, given the statutory provisions applicable, is it a matter on which to found delictual liability or the element of wrongfulness for the purposes of delictual liability? So that is the first issue. And we submit that when one looks at how this court in the BE case dealt with the question of wrongfulness, and despite the fact that there had not been compliance with the relevant statutory provisions, it looked at the question of on what basis, even if there was a violation of the statutory provisions, would that translate into delictual liability? That was the issue that we raised in regard to the High Court's judgment. But when one looks at the manner in which, or the basis in which the applicant in this case says that delictual liability ought to follow because of the duty of care, not because of the duty of care, but because of the constitutional norms of accountability and Section 195 of the Constitution. Then the question arises, and that's the issue we address at paragraphs 43 to 54, and that's the only reason we raised it. If this court were to say that wrongfulness is a live issue, then the question is, should it then translate into wrongfulness for the purposes of holding the tortfeasor delictually liable? And we submit that when one looks at the issue of how do you measure Section 195 against the requirements of the duty of care in healthcare facilities, how would it be in the interest of justice? And that's not for the purposes of deciding whether to entertain the matter, but for the purposes of jurisdiction. Would the question be a matter that this court will say that delictual liability should follow because these norms were not accepted? And we submit that, as was said in the SCA in the BE case, that because the duties that are imposed on the MEC or the duty that the applicant says vests in the MEC, because these are administrative law, these are matters that arise in terms of Section 33, the right to administrative justice. In that case, there should be a public law remedy, not a private law remedy, in terms of allowing a claim on the basis of the act being wrongful for the purposes of dealing.
Mr. Soni, can I ask you, although I didn't quite understand the answer, but the applicant pegs jurisdiction on two aspects. As far as wrongfulness is concerned, the applicant says that even if we exclude wrongfulness because of this assumption that was made, Wrongfulness is closely linked to and connected to negligence, and therefore, on that basis, this court would have jurisdiction. And the second aspect, which I'd like you to comment on, is them pegging jurisdiction as far as causation is concerned on the application of the Lee test. What do you say about those two?
Yes. Justice Majid, as far as the first issue goes, sorry, can I ask for the first question again, please, Justice Majid? I had my thought in it.
Yes, well, Mr. Budlander submitted that even if we exclude wrongfulness for considering jurisdiction grounds,
yes. Oh, sorry,
because of the assumption that was made, it's so closely linked to negligence that this it would engage this court's jurisdiction. That was the first one.
Yes. Can I deal with that? This court has made the point in several cases that, one of them is the case of Mashangwa, where it emphasized that the question of wrongfulness is quite separate from the question of negligence. And although both, in a sense, deal with what is reasonable, essentially, on the question of wrongfulness, the test is what are the legal convictions of the society on the question of whether somebody should be held liable. Now, that's a quite separate test from the reasonable person test that is applied in negligence and that has been applied in this case. Namely, would a reasonable doctor in the position of Dr. Sibeko have attended to other duties at a time when she should have been, or when it is alleged she should have been operating, and considered whether the other emergencies were less pressing for her to deal with. So in that case, we submit that strict line between wrongfulness and negligence, although both involve elements of reasonableness, should be maintained. And we do not, we submit that the fact that a new basis for negligence is being suggested is not a basis to invest this court with jurisdiction. So the answer,
second aspect is causation, the Lee test.
Yes. In Mashangwa, this court made the point because, and I don't need to go into the history, the test in Lee had attracted a great deal of academic interest and comment. And in Mashangwa, this court made the statement emphatically that the test in Lee was not a different test from the traditional test. Now, Mashangwa case is quite relevant for this because that also involved a negligent conduct by an organ of state, as a result of which a member of the public was injured. Now, we submit that this case is very similar because it happens over a confined period of time, a time when the patient is being treated at the hospital. In the Lee case, the issue of how could Mr. Lee have contracted TB except through other persons and so on, the difficulty of establishing negligence in that case required going outside the parameters, but it was only in regard to the circumstances of the case. And had this court not emphatically said in Mashangwa, but in the ordinary course, and we submit this case, the case before the justices, is in fact along the Mashangwa lines rather than along the Lee lines.
Yes, thank you.
Now, can I then, justices, deal with the question of what were the issues that arose in this case in the High Court, in the SCA, and that now arise in this court? And we submit that what is quite clear, and it's in a sense a refrain that we keep making, that this is an ordinary delictual claim. The fact that it is said that the theater was not being used at particular times, and in the words of the learned judge in the High Court, it lay fallow. We submit that that betrays a misunderstanding or a refusal to accept the evidence, and the only evidence led on that issue, namely that of Chauke, of Dr. Chauke. And you will note that the learned judge, in her judgment on that issue, did not refer at all to the evidence of Dr. Chauke. Now, it is important because at the end of the day, all that the respondent can do in a case like this is present the evidence that's available. What is significant about the evidence of Dr. Chauke is Dr. Murray, who gave evidence for the plaintiff, accepted that the process and the procedure that was followed at Charlotte Makeke is what is followed at Tigerberg. She of course said, well, in certain respects, we do A, B, and C. But she accepted that, generally speaking, the same doctor would attend to other matters as attends to cesarean sections over the weekends. Now,
Mr. Soni, I'm sorry to interrupt you, but in respect of Dr. Chauke's evidence, it was a somewhat abstract account of the kinds of things that Dr. Sebeku may or may not have had to attend to. There weren't actually medical records for the day as to what was happening in the various wards. And one of the points that Mr. Budlander makes is that he says the onus was on your client to produce those records and give a factually informed account as to what else Dr. Sebeku was doing when the theatres might otherwise have been used. What do you say about that?
Justice Interhalter, in a sense, the judgment of Justice Rogers deals with that issue because two questions arise. Firstly, the question of the non-use of the theatre during those 3 downtimes was raised only during the course of the pleadings. And what had happened during the trial, and I'm not giving evidence, I'm merely pointing out the basis on which the issues arose and why it, depending on what was asked, the defendant in the trial produced everything that was asked. Now, the defendant was, in a sense, confined by the nature of the pleadings and the nature of the evidence led and the submissions that were made to the different witnesses.
But help me on this score. If once the issue is raised in the course of the trial and no objection is taken to the raising of the issue for the reasons that you've explained, and no prejudice is alleged, then the question is who bore the onus in respect of that, at least from an evidential perspective, as to adducing evidence as to what else Dr. Sibeko was having to do so as to leave the theatres not as fully used as they might have been.
Justice Unterhalter, in hindsight, what should have happened is the record for the records of all the patients for the day should have been made available so that both the High Court, the SCA, and this court could have considered for the purposes of determining the reasonableness of Dr. Sibeko's conduct for the day. The question really, though, is that given the issues as they arose, it would, we submit, be unfair and contrary to the provision, to the suggestion in Mashangwa at paragraphs 41 to 43, that the defendant ought to be held liable for that. And I make this point, Justice Unterhalter, because when the matter came up before the SCA, one of the questions that arose was, well, what test do we use? And it was put to the justices in the SCA that the test as set out by this court in Mashangwa should be the one that was used. And that is why the issue of evidential burden arose, because it was raised for the first time in the SCA. But by that time, the record had already been done. And at the end of the day, if one looks at the test set out in Mashangwa, in regard to the security guards issue, the court came to the conclusion, well, we have all the evidence. We don't know if there is more evidence, but given the evidence we have, we make a finding that negligence on that issue has not been established. So to the extent that there may have been a general duty, given the fact that the overall burden lay on the applicant to ask for whatever having regard to the pleadings and so on she wanted, we would submit that had there been a request and it was refused, the position might well be different. Just may I deal with a quite separate issue, and that is the manner in which the SCA dealt with the question of the questions that were before it, namely negligence and causation. Now, you have before you three judgments: the judgment of the High Court, the minority judgment, and the judgment of Rogers AJA. We submit that the judgment of the majority judgment, which was penned by Justice Rogers, is as comprehensive an exposition of the issues that were before the court as one could get. He dealt with every issue that arose in the court, that arose from the papers, and that arose during the course of argument. And we submit that there is no basis, except if this court were to find that there is a constitutional issue, for interfering with it. But assuming this court were to find that there is a constitutional issue, then we submit that the findings in regard to negligence and causation that were made in the majority judgment ought to stand. They are in our respectful submission unassailable given the information before the court. And for that reason, we would submit that even if this court were to decide that it has jurisdiction, and we submit it doesn't, and that it is in the interest of justice to hear the matter, which is the second requirement for this court to exercise jurisdiction, that it should not. But I would like then to return to the question.
Mr. Sonny, can I just ask you to assist me on a submission that was made by Mr. Badlander? In assessing negligence, he says that we should not confine our attention only to the period when the emergency arose in respect of his client. And he was addressing us on the downtime issue. He said that, in fact, this hospital should, from the time that they were making the plan, should have anticipated that they would receive emergencies. And they should not have allowed that the theater remains unused at any given time. So he says that we would be wrong if we confine ourselves at the stage when the emergency arose, but that we should make a finding that as a provincial hospital, this hospital should have foreseen that emergencies can arise at any time.
So let me give this answer, that although that is a point that the respondent took at the SCA when it appealed against the judgment of the High Court, that point was not persisted in, certainly at the level where it was suggested that the question of negligence ought not to be considered at all. Because in that context, reliance was placed, and I appreciate what Justice Unterhalter has said, that in a sense, Dr. Chowke's evidence was of a generic nature, dealing with what would happen. We don't know what actually happened. But there is one factor that must be taken into account, and that's the overall scheme. It was a matter that was raised in cross-examination with Dr. Murray, and that is when one looks at what happened throughout the day, even where there were C-sections on mothers whose children were suffering from fetal distress. All the cases for that day came out reasonably. Even the APCA scores, as I remember it, there was one APCA score of 6 at 1 minute, and then it moved up to 9 at 10 minutes. But I make that point to say that the suggestion in the High Court and by my learned friend is, but this place, they were not attending to the relevant duties that they had. Now, we accept, and we must accept, notwithstanding the paucity of the evidence on this issue, that all hospitals would have a registrar who would attend to emergencies, not only in respect of cesarean sections. So this is the proposition I posit. Let us say a mother is having an ordinary vaginal delivery, a normal vaginal delivery, and an emergency crops up. It is Dr. it is Dr. Sibeko who would have to attend to that. Of course, we don't know whether she had any, and that is the reason why the theater was not being used. But what we do know is, for the entire day in that ward, in the maternity unit, this is the only incident of an unfortunate nature that happened. And I say that just in general, in saying that when one says that you had to attend to emergencies, the emergencies are always on the question of, or one way to determine them is what went wrong, and the other way to determine them is what didn't go wrong. And my answer, Justice CT, is that when one says that the hospital or the theater ought to have been used at that time, one cannot ignore two things: the evidence of Dr. Chauke, for one, and also the evidence of Dr. Murray about the practice in other hospitals and the fact that people are attended to, that other patients are attended to besides cesarean sections. Just Madlanga, can I there is just something that I would like to.
Yes, it's on me.
Justice Madlanga, I have said what I want to say, and unless there are any further questions, I have nothing to add to the heads where we have addressed all the issues we wish to address before this court. And we would just appreciate it if the justices would consider what is contained in the heads. Yes.
Advocate Sonny, sorry to my brother presiding. It's just another small issue that I hope you may be able to help me, because it has featured both with you and Mr. Badlander, the issue of the missing records. How does one deal with that in where we find ourselves if we get to dealing with this point? I mean, there should have been records, if I'm not mistaken in saying that. The records are not there. So there's no evidence as to what happened on that day as far as this particular witness is concerned, not witness, claimant is concerned. How does a court deal with this issue where there are no records, when records should have been there in the first place? Is it something we need to look at? And what impact does it have on other parties' case, if any?
Justice Mlambo, may I make this point that usually what is discovered and what is requested in discovery and so on is determined by the pleadings. Now, one knows, because the majority judgment deals with the issues of what was said during the issues in the pleadings and the issues that went way, way beyond the pleadings. That they were canvassed in evidence is what did happen and what constitutes the record. if one looks at the trial record, what one would find is that at no stage was it suggested by the plaintiff that the defendant is not cooperating with presenting documents or records or whatever. Now, in a sense, when one comes, having gone through the High Court, the SCA, and coming to this court, one then appreciates that the issues that were before the High Court, the issues that were raised, were perhaps not all the issues if a constitutional matter should arise. But part of the problem is the constitutional issue didn't arise until the application for leave to appeal was made to this court. And so in determining what records would be available, one needs to ask, well, given what were the issues before the lower courts, was everything that was necessary to deal with those matters dealt with?
Yeah, I think, thanks for that. What I wanted to do is to give you an example. We know what cost the first downtown. We don't know what cost the following two downtowns. And we don't know that because we don't have the records.
Yes. And Justice Mlambo, you will remember, well, two things about that. One is the plaintiff at the trial said she was not she was not placing any reliance on the first downtown, but I'm not making a point about that. But the first downtown, we gathered from the record of, I think it's CM, because she was supposed to go into surgery and her procedure had to be postponed because of the lack of grants. So it was on her record that we were able to find that out. Now, whether because of the other downtimes, there ought to be other records, we don't know. What would have helped, obviously, is the various tasks that were performed by Dr. Sibeko on that day from the other sections of the unit, if they would have helped, but they didn't become relevant at the trial, and records were not made available.
Thank you very much, Mr. Soni. Yes, Mr. Badlender.
Thank you very much, Justice Madlanga. Justice Madlanga, I have listened carefully to the debate between my learned friends on the bench, and I propose to deal with 3 points in reply. Firstly, I owe Justice Theron an answer on Lorero. Secondly, I will deal with the question of whether the wrongfulness issue is a live issue and the interest of justice in that regard, and that's the argument of our learned friend. And thirdly, I will deal with the question of what the evidence was and the question of the records. If I could begin with Lorero. Justice Theron, you put to me the question of whether Lorero was at odds with my submissions on this court's jurisdiction. And I have gone back and reread Lorero. I respectfully submit that it's not at odds with my submission, because what Lorero found is that where wrongfulness is an issue, and there is debate about how wrongfulness should be developed or applied in the context of the Bill of Rights, then that is a constitutional issue. But the court certainly didn't say, on my reading, that that is the only way that a constitutional issue could arise in the context of a delictual claim. And so my submission is that while Lorero doesn't help me if wrongfulness is not an issue, it also doesn't harm me. It essentially says little more for present purposes than that wrongfulness is a constitutional issue. And I would return to the point that I made, which is where the common law is giving effect to fundamental rights, as this court held in Law Society versus Minister of Transport, then that does raise constitutional issues, and the debate will become one largely of the interests of justice. On the second point, Justice Madlanga, our learned friend, with great respect, has twisted and turned to suggest that wrongfulness was not an issue either before the High Court or before the SCA, and it has only become an issue now in an attempt to smuggle in an appeal. That, with respect, is simply not so. And could I just trace the sequence of events? You will recall that I took you to the stated case. And then after the stated case, I took you to the judgment of the High Court. And could I commend to you page 1572? It's volume 16, page 1572. And Judge Fisher says at paragraph 33, to my mind, the picture that emerges from the records in this instance is not one of a misallocation or lack of resources, but rather a mismanagement of the available resources. So Judge Fisher was dealing with the various grounds that were raised. She held, of course, that it wasn't enough to complain about the fact that there was only one operating theatre operating rather than two, because she said that was a matter for the state to determine. But she said the question that emerged was misallocation of resources, was mismanagement of the available resources. That is really, and then she made the point about the facility lying fallow, etc. And again, she made that point at 1574, paragraph 40. There was no suggestion by her that the question of wrongfulness on this score was common cause. She was dealing with it. But more importantly, we then get to the SCA, and I wasn't in the SCA, and my learned friend says that the question of wrongfulness was not at issue in the SCA. But with respect, it's difficult to understand that when you look at the judgment, because if you begin with the minority judgment at 1585, paragraph 17, you will see there that the minority squarely considered whether there was some legal duty in relation to the organization of the operating theatres before the mother was, before my client was received into the hospital, and concluded that there wasn't on the basis of AN versus the MEC. Now, we've explained at length in the heads why that conclusion is wrong and why AN is certainly no authority for that proposition. AN simply says there's a duty in respect of patients who are in your hospital. It doesn't say there is no duty in respect of patients before they get to the hospital. So the minority, with respect, was incorrect and got that wrong. The majority then dealt with it at paragraph 56, which we spent some time on, and that's at page 1599. And there, the majority assumed, as we've discussed, that there was a legal duty to exercise said that there was a legal duty to exercise reasonable skill, care, and diligence, and said, I'm willing to assume that this was a legal duty, that this included a legal duty to manage the unit's resources with reasonable efficiency. So this question of efficient use of resources is not something dreamt up in order to obtain an appeal. It is something that arose in the High Court. It is something that arose on the evidence, and it is something that arose in the SCA. And we come to this court, and you would have expected that if the wrongfulness issue was not at issue, then the response of our learned friends would have been, well, there is no issue about wrongfulness. We accept that there is a legal duty or assume that there is a legal duty to manage these facilities efficiently, but we say there was no negligence. There was no breach of that duty. But they don't say that. They instead, as I demonstrated in my argument in chief, devote pages and pages to saying that there is no legal duty, that there is no wrongfulness, and that this falls entirely outside the bounds of delict, and they rely on the BE case in that regard. So this court is faced with a situation, and this echoes the questions put by some of the justices, where there is not yet certainty in our law as to whether there is a legal duty regarding the management of these facilities. If the SCA judgment, the majority doesn't resolve it because it leaves it open on the basis of its assumption. The minority resolves it, but with respect resolves it in the wrong direction by making an incorrect finding based on the AN judgment. which doesn't operate as authority for that proposition. And so if this court is not to grapple with it, then the law will be left in a state of flux, and lower courts with respect will be unable to know what the state of the law is. If they're to know what the state of the law is at all, they would have to follow Judge Ledwaba's summary of AN, which is to say there is no legal duty. So it's important to say, I beg your pardon, it's always tempting on difficult issues to try and leave them open for future cases. This is a very difficult case to do that in, because what you're going to do with respect is not leave it open, properly speaking, but in fact leave an apparent view that there is no such legal duty. And we say that when we're talking about the interests of justice, that is fundamental, and that it is in the interest of justice that this is resolved. And like in Mashongwa, where this court said there were divergent views expressed by the majority and the minority, and therefore in the interests of legal certainty, the interest of justice favored granting leave to appeal, we say that precisely the same applies here.
Mr. Budlander, but if we have to apply the interest of justice test to the facts of this particular case,
yes,
deciding that issue might not affect the outcome of the matter. The outcome might still be as was found by the SCA. And in those circumstances, would the interest of justice dictate that we hear the matter or militate against us hearing the matter?
I accept, Justice Theron, that if this court considers the wrongfulness issue, and if this court considers that even if wrongfulness applies, the SCA was correct on negligence and causation, then the court will not want to be drawn into the wrongfulness question, and it would not be in the interest of justice. But my submission is that the opposite is true. If the court accepts that wrongfulness is there, for the reasons we've articulated, the SCA majority was incorrect, and negligence and causation were there, and therefore the outcome would be different. So I accept that the court does not go on academic frolics of its own, and that the court will need to be satisfied both that there is a legal issue with wide ramifications and that it might make a difference to the outcome of the case. I accept that, but I submit that both of those are satisfied in this case. If I'm wrong on that, the court will refuse leave to appeal. And then finally, Justice Madlanga, on the question of the evidence, with great respect again, the MEC blows hot and cold, because the MEC says that they adopted a stance that even though issues were not perfectly pleaded, they would produce documents and they would act in a transparent and open manner because of what this court said in Mashongwa about the duties of an organ of state. And of course, Mashongwa is an appropriate case to look at because it isn't a duty of an organ of state, whereas Lorero was about purely private parties. But what the MEC says is we decided to approach it, play open cards, not take technical points. And they do that for as long as it suits them. But now when the rubber hits the road and the shoe pinches, when the point is made, but there is a legal issue here and it does need the attention of this court, and there is no evidence about the downtimes, now they revert to form, they revert to type. And now we are told, no, it wasn't properly pleaded, it was never an issue, you didn't call for the records, etc. With respect, that's not appropriate. The appropriate response from an MEC is the one that was initially put out, which is to say, we accept a duty to put out the records. And if the records don't exist, then they had to put out some form of evidence in substitution of the records. And that's where Justice Mlambo's question, the question posed by a number of the other judges, come in. If they needed the records, they should have asked for a postponement to put them up. If they couldn't find the records, they should have said so and put up the appropriate evidence. But what they can't do is not put up the records and then complain that my client hasn't established her case. So our submission is that when you step back, there is an important legal issue that arises on the question of wrongfulness. That is determinative of the case, because if one accepts the finding of wrongfulness that we've urged for, and you accept the questions of negligence and causation we've argued, then the plaintiff's claim should succeed. And so we would ask for the application for leave to appeal to be upheld, for the appeal to be upheld with costs, including the costs of two counsel. And of course, this we would submit that as in the SCA, this is a case where if we succeed, we're entitled to costs. And if we fail, there ought to be no award of costs on the basis of the usual principles applicable.
Thank you, Mr. Budlander. Thank you to both counsel. Judgment is reserved. Court adjourned.
court pleases.
As the court pleases.
Proceedings have concluded. The host will now terminate the meeting.